Hi, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida bar tells me that I have to say this, but I will tell you, nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Today, I'm going to be talking about nurse-centric short and long-term disability claims. Nurses are the backbone of the medical community, and they've been integral in combating the COVID-19 pandemic. Disability claims are highly scrutinized, and the same goes for disability claims of nurses. So let's take a look. First, I'm going to talk about a registered nurse with Cushing disease who was awarded line of short-term disability benefits. Next, I'm going to talk about a nurse anesthetist who was self-treating their insomnia and unfortunately passed away. We'll talk about why that claim got denied for accidental death and dismemberment benefits. And lastly, I'm going to talk about how the general workplace standard of occupation and a medical trainer nurse disability policy doomed ultimately her disability insurance claim. Now, just because I'm talking about nurses doesn't mean that there isn't anything that you can learn. So listen up. Let's take a break first, though. Welcome back to Winning Isn't Easy. I'm going to talk about how the general workplace standard of occupation in a medical trainer nurse's disability policy ultimately doomed her disability insurance claim. One of the most important definitions in a disability insurance policy is the definition of occupation. Why is that? Well, to get your disability benefits, you have to prove that you're unable to do the material and substantial duties of your occupation. How your policy defines the term occupation and what your occupation was at the time you became disabled can make all the difference in whether or not you get your disability benefits. And I think the story of Nurse Ann Kay, found in the case of Kay versus Hartford Life, will really illustrate the importance of understanding the policy definition. Kay worked as an operating room nurse for over 13 years and developed low back pain. She ultimately had to change positions with Syneron, and she became a clinical specialist on a per diem basis. Now, she underwent back surgery, subsequently recovered, and went back to work for Syneron. However, when she went back to work, Syneron had merged with Candela Corporation, and they hired her as a full-time clinical specialist and a medical device trainer. Now, unfortunately, her low back pain returned. She had limited range of motion. Her treating physicians took her out of work. Diagnostic studies showed that she had lumbar degeneration above the old fusion. And on physical examination, she had mild radiculopathy as well as a chronic S1L5 radiculopathy. So she was having back pain with radiation of pain down her leg, which is clearly painful. Now, she also went on to develop cervical degenerative disc disease and spondylosis in her neck, but there was no nerve impingement. When she applied for her disability benefits, she was paid short and long-term disability benefits by Hartford. But Hartford subsequently terminated her benefits, noting that she had to prove, based on the policy, that she could not perform the essential duties of her occupation as generally recognized in the workplace, not as performed specifically for her employer. Clearly, Hartford was looking for a reason to deny the claim. They had a vocational evaluator look at her occupational history and the description of her occupational duties. They concluded that her occupation required her to provide support to sales. She would travel to customer locations. She would move devices, and that required her to sit and stand for hours. She would push and pull up to 20 pounds. She would lift and carry up to 20 pounds. So once they established what they thought her occupational duties were, they went on to have a paper review physician look at her medical records. And guess what? That liar for hire medical reviewer said, she could perform those duties. And when her claim was denied, she appealed. And she said, look, You have incorrectly determined my occupation and the strength level at which it's performed. And you clearly don't understand that my diagnosis renders me unable to meet that applicable strength level. Well, on appeal, what did the Hartford vocational evaluator conclude? Hartford had another vocational analysis done, and the VE concluded that her occupation was a combination of a training representative and a general duty nurse. The occupation's essential duties involved administering treatment in accordance with nursing techniques and preparing medical equipment, and developing and conducting individual and group training programs for employees for industrial, commercial, or government clients of the equipment and the treatment. And lastly, the VE concluded that the physical demands were of a range from light to medium, with occasional lifting, carrying, pushing, and pulling of up to 50 pounds. What did they do? Well, Hartford did the same thing it did the first time. It sent the case to a second liar for hire paper review doctor. That doctor looked at her records and disagreed with her treating physician about her capabilities. And as a result, Hartford said, we think you can do the essential duties of this occupation as we've defined it. Obviously, this case ends up in federal court. The analysis starts with what was the policy definition of occupation that the court was required to apply. Now, the policy provided that a person was disabled if they were prevented from performing one or more of the essential duties of your occupation. The term your occupation was not subjective, and it didn't consider her specific duties as she performed them for her employer. Rather, this policy had an objective definition of occupation as recognized in the general workplace. In other words, she had to prove by a preponderance of the evidence that her medical diagnosis prevented her from performing an essential duty of her occupation as recognized in the workplace. Now, unfortunately, Kay and her attorney did not do a very good job in the appeal of explaining why her medical condition prevented her from performing her occupational duties. And she never challenged this faulty vocational conclusion on appeal after the second denial. Kay should have attempted to rebut Hartford's vocational analysis that concluded that her occupation was a combination of occupations and that her physical demands were in a range of light to medium. Secondly, she didn't provide any proof that she was unable to perform any one of those activities. She didn't even submit a functional capacity evaluation, which is a physical examination to determine a person's strength levels and their tolerance levels. That would have been key. Thirdly, she didn't have her physician address her restrictions and limitations and rebut the opinions of the liar for hire paper peer review doctors who said she could do these duties. And lastly, she didn't submit a vocational report contesting and rebutting the conclusions of Hartford's vocational evaluators. The court obviously rejected her argument that Hartford was wrong and that they should just accept her doctor's conclusions. The court noted that the doctor never explained the restrictions and limitations with any kind of detail, which of course was another mistake, which could have been addressed by taking the statement of the physician. These were fatal mistakes that doomed her claim. She failed to provide Hartford and give the court the necessary proof of her restrictions and limitations. She didn't challenge the vocational classification of her occupation, and she certainly didn't provide the court with the information as to how her diagnosis and her symptoms impaired her ability to perform her occupational duties. And as a result, this left the court with no choice but to accept Hartford's paper review doctor's opinion about her restrictions and limitations, and their opinion as to why her diagnosis and symptoms didn't prevent her from performing at a medium duty level. As a result, the court upheld the claims denial. And this is a sad example of what can happen when you don't have an experienced ERISA disability attorney representing you in the appeal. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, consider liking our page, leaving a review, and sharing it with your friends and family. Also, I would love it if you would subscribe to this podcast. You'll be notified every time a new episode comes out. By the way, I also want to tell you that we have our 2022 Cavey Law Scholarship. It's up and running, and we're taking entries until August. You can head over to caveylaw.com, /scholarships to enter or to tell friends or family about this great scholarship opportunity. I hope you tune in next week for another insightful episode of Winning Isn't Easy.